Welcome, everyone, to the Save Our Green Space virtual town hall. Barbara Ramsey here, Chair of the Canada Green Space Protection Coalition. Thank you for joining us tonight at this town hall. We will record our YouTube live stream and we'll be sharing the link on our website for those who could not join us or for those that have to move along partway through the evening. Our hope at the outset is to wrap up towards 8:30, but we'll let you be the judge with the volume of questions that we receive over the evening. Let me introduce right now the folks from the coalition who have joined me here tonight. Alyssa Tompkins, our Chief Counsel and partner at Casa Sakely LLP. Jeff McGowan, the coalition president and well-known business leader in our community. Sue Dodge is the principal at Dodge Inc. and also a director at the KGPC, and she's organizing our question and answer this evening. And behind it all, managing the tech functions, are Karen Noseworthy, secretary to the KGPC, and Neil Thompson, a member of our board and the president of the Canada Beaverbrook Community Association, and the magician. Note, please, our email for the town hall this evening, townhall@ourcanadagreenspace.ca. And just a reminder, we've been collecting questions over the past week, and we're going to continue to review your emails at that address. And if we don't get to them tonight, we have every intention of following up with you, whether it's in one of our e-news or loading questions and answers onto our website. So please don't hesitate to feed us your questions. We'll find a way to get back to you. I'm going to signal Neil for my next slide, and we're going to get started. It's been 3 years into this battle to save the very essence of our community. 60 years ago, our famous architect, Bill Tarrant, had the good mind to develop a community that was to be premised in its green heart, living with the land, walking through it, not just on it, respecting nature, its brilliance, the biodiversity, and the strength of the streams and the ponds and our Canadian shield. Living with the seasons teaches life's lessons, change, and it does develop resiliency and tolerance, I believe. Living with our neighbors and sharing space respectfully. That's Canada North. Live, learn, work, and play in one community with a forward vision. That's Canada North. Embracing new technologies while holding our environment close. Also Canada North. And along the way, building the largest high-tech park in Canada, ready to compete and explode globally around 5G and all of the economic growth it will bring. Next slide, please, Neil. Another vision of our Canada. 40 years ago, a younger generation of Canada leaders crafted the documentation that allowed the expansion, excuse me, of the Tarrant vision. They had a good sense to put it in writing. We cannot say those words and not mention Marianne Wilkinson, who I know is always watching and wishing us forward. They crafted a legal document, the 40% agreement, as we all know it now, ultimately endorsed by the Regional Municipality of Ottawa-Carleton to provide this community with the expansion it wanted, but to deliver it in an ethical context. Natural and open recreational space was not intended to be a vision. It was intended to be experienced. To ensure that end, they then deeded the right to use the property to every lot holder in what was then known as Marchwood Lakeside. Expansion began, the community flourished, schools were built, the golf course lands were carved out of the Marchwood Lakeside community, and more expansion followed into the 90s. Next slide, Neil. Just over 25 years ago, Clublink came to Canada North and signed a purchase agreement for the KGC lands, which included accepting the 40% agreement and its restrictions and this beautiful space, accepting a restrictive covenant that identified the stormwater management function inherent on the land, and committing not to alter its grading. Unfortunately, Clublink seems to have decided to throw away these obligations. It no longer wants to share the recreational space and golf course services it agreed to provide. It no longer wants to provide the accessible open space it agreed to share. Clublink acts as though it does not have to honor any agreement, and it has found in Minto and Richcraft the enablers, the buyers, to extricate it from these arrangements. Integrity doesn't seem to matter, only the money. Let's talk about it all tonight, what we collectively and individually can and must continue to do about that. Let's get to it. Next slide, Neil. We know some of you really, really well. The Gen Zers in our community would call us besties. The coalition has fielded a ton of calls over 3 years. I should have logged them. I did not. A lot of listening and talking on street corners, sidewalks, school parking lots, cart paths, trails, Loblaws, even the library, Shoppers, Farm Boy, you name it. We talk about this issue everywhere. We've written and shared 55 e-news in the last 2 years. That's hard to believe, isn't it? You tell us they're valuable. We want them to be valuable. You tell us you rely on us to keep you informed and aware of what is going on. We believe it's critical. That's what keeps you engaged. That's our commitment to our supporters. Next slide, Neil. You may remember this night in November 2019 at Earl LaMarche High School. Over 700 people from our community turned out for our first community meeting. Clublink and their friends were there too, sitting in the seats next to you, in the crowd among you, listening. How do we know that? They thought it important enough to have their lawyer report on it during the Ontario Land Tribunal hearing, which is just closing, just wrapping up now. In fact, they reproduced our correspondence with our mayor as though a community group writing the mayor and encouraging his support is a crime of some sort. And you can bet your last dollar that if Clublink is not watching tonight, their friends from Minto and Richcraft are in the audience right alongside you. I say that not because it will change what we say, but I think you know we may have to change how we say it. Their number one game plan is not building an organization bent on being the best developers they can be, consulting widely, designing creative communities with cutting-edge technologies, and then investing in their proposed communities. Instead, their plan is to obscure the path of consultation for communities who disagree, making it too hard and too expensive and just damn time-consuming for you and the community to raise your voice and have your say and be heard in a way that will deliver the kind of change that will design community resilience. We hope the KGPC has helped you with that. Next slide, Neil. Tonight, however, we're here to update you and say, after 3 years, We're about to round the corner in this long trek, and we're heading in to the last mile. On the next slide, I want to introduce you to the topics I'm going to speak to tonight and say how grateful we are for your company and your choice to share your valuable time. We're going to ask for your help tonight. We need everyone to pull together for this last mile. I'm going to start with an update on the Ontario Land Tribunal, Neil, if you move to the next slide. And it is almost behind us, with final written submissions due to the panel tomorrow. It is not designed for community participation. And this is a problem that the community has had with it from the beginning. It is not a vehicle to consult or engage with the community, but it is designed to force developers and municipalities to come to agreement, to drive development forward. Municipalities attend by legislation, the Planning Act. The KGPC saw the OLT as a necessary investment to backstop the city with quality expert opinion and ensure there were good oppositional arguments to the Clublink proposal. Our experts in November and December put in huge hours of preparation leading up to the hearing. Over the length of the hearing, 7 to 12-hour days in testimony or preparation for the next day drove costs upwards to $8,000 to $10,000 per day, and some days more if multiple witnesses were involved. We are proud of our expert evidence and arguments on the prematurity of the Clublink plan, and we feel our experts backstop the city's case on the stormwater management issues very well. On the issue of the environment, the environmental assessments and contamination remediation plan, we are shocked to this day at the city's laissez-faire approach to site contamination and its management. And this was highlighted by its failure to stand up in defense of the very clear position outlined and described in our experts' testimony. Having said that, the OLT is primarily behind us now, and we will have to wait for a decision. Next slide, Neil. In that we don't have that decision today, and the OLT panel has a broad swath of options open to it, we can only sit and wait. But we are working deliberately every day on this file to keep our community in what some describe as an awful game. While the planning may be behind us, this week we have undertaken a new legal action, and we have more news on that for you tonight. And we also want to say, join us, take resolve. We are going to pursue this further. And to that end, we also have more money to raise for them. Next slide, Neil. I want to take this opportunity as I approach the issue of the City of Ottawa to thank Councillor Kathy Curry, who is in the audience with you tonight. She has helped us move forward on this trek every day since she arrived in November. Our fight has been made better as a result of her work and the effort of her team here in the Ward 4 constituency office. In the past 5 months, we can also say that we have had great support from the mayor's office and his team, led by his chief of staff. We believe the political arm of the city understands what our community wants and see value in the opposition that the KGPC has brought with you to this fight. On the matter of the question I get asked literally daily, does the city really want this development stopped? At this particular point in time, I think it is fair to say that city staff have responsibilities beyond the interests of only Canada North, and developers' fees and tax dollars drive the behemoth, the machine that is the city of Ottawa. It is difficult with some of what is seen and heard to believe that everyone on Laurier Avenue shares our concerns. But I do believe that we have an ally in Councillor Curry, and right now we have an ally in Mayor Jim Watson and in the mayor's office. Obviously, they have had a lot of issues to deal with of late, but right now, that is the view from where we sit. The city has committed to pursuing the 40% agreement to the Supreme Court of Canada, and we understand the depth of that commitment. We hope and trust that all good efforts will go into that case because it is definitive and it will be determinative. I'm not going to go into that because we have an expert with us tonight on that subject. So I'm going to leave the rest of that discussion to her. On the next slide, Neil, I'd like to address the issues around Queen's Park. And we have another friend there. Our MPP, Marilee Fullerton, has been very supportive for us, arranging meetings, identifying folks to talk to in and around Oakville, the lucky recipients of Queen's Park help on the matter of another Clublink file, Glen Abbey. There are many views and reasons on what Queen's Park should be doing or not doing. We have had different levels of interaction with government ministries listed here, varying from letters to virtual calls. There is no great sense right now that an MZO or similar pearl is coming from Minister Steve Clark, Minister of Municipal Affairs and Housing, through his interactions with our mayor. But we can always hold fast. We keep at it. We continue to call, we continue to write, and we ask our representatives continually to keep trying. The most important thing to remember, at the end of the day, 2022 is an election year. Everyone in Canada will have 2 votes. Next slide, Neil. So before I end my presentation, I want to spend a few minutes talking about finances. And not easily done. We get a lot of questions asking us, well, spell out exactly how much money you need and what you're going to spend it on. And that is very, very hard to do. Writing a business plan, writing a financial plan is not that difficult when you know exactly what services or what products you're committing to deliver and how you plan to do that. In our situation, it's very, very difficult. In our first 3 years, as people have heard me say very many times, we don't get to drive this bus. We've been trying to wrestle the wheel free, and we have finally just done that with our legal action that we're going to tell you about this week. But the reality of it is, it's very hard to control the agenda when you're in the planning arena, as we are here, with developers, their deep pockets, the money they have, the partnerships they have, and you have huge municipalities on the other side. But we waded into this 3 years ago, and I want to tell you how well we've done, and we've done very well. In the past 2 years, during the COVID pandemic, we have raised $300,000. About $100,000 of that was spent in 2019 through 2020 pursuing the first arguments on the 40% agreement. So lots of steps have gone in the water under the bridge. But remember, we had to seek intervener status. We then had to proceed through delays. We then got in front of Justice LaBrosse. We had to wait for a decision there. And so it dragged out over a long period of time. Subsequent to that, our focus has been on the Ontario Land Tribunal. And while we knew going into it, it was going to be expensive, we had no idea just how much. And clearly at this point, we're at over $200,000 in expenses for the Ontario Land Tribunal. And based on the thumbnail I gave you earlier, I think you can see how quickly it can get there. We don't know whether we were successful, but we do know that if we are successful, there will be no shovels in the ground in the short term. We believe the city and our joint case against the prematurity of the OLT was a good one. And we will wait to see the results. But nonetheless, the $200,000 expenditure backstopped the city and we were able to make sure and ensure that the proper presentation was in front of that panel. The next question, how much do we need? And I don't have an exact answer, but I have the right answer. And that is, we have to have enough to ensure we win and end this situation permanently. Our best estimate right now is another $250,000. And that is our goal going forward. Next slide, Neil. We haven't filed our 2021 year-end tax return yet. We just closed the year on December 31st. But here's a couple of clips. I just want to remind you how steadfast we are in our efforts. In 2021, fundraising generated only about 40% of our total revenue. The rest of it came from donations. So we are what you are. Without you, the coalition will not be able to carry forward, quite simply. Will this get easier if the pandemic is behind us? We hope so, because that number is almost the reverse of what it was the year previous to the pandemic, when we had the luxury of the revenue from our gala event. Next slide, Neil, please. And this is just a slice of our expenses. What I want you to take away from this is the seriousness with which we approach our expenditures. 12% of our expenditures last year were on events. They are delivered backstopped by volunteerism. Tens of thousands of volunteer hours have now been put in by this coalition. The most important part of it is that fully 84% of our revenue has been driven directly towards procuring the expert professional services we need to win this. And you need to know that we intend that to continue. We will continue to be a volunteer-driven organization, and we will continue to ask for your volunteer efforts, and we will need to continue to ask for your donations. Next slide, Neil. And to give you a flavor and something to think about, this was a stone that we didn't craft, but was actually created and left on the green heart of our community. So today, I'd like you to get your head around, how can you save our green space? How would you like to honor the memories that you have of our Kanata North community premised in the environment? How will you protect your tomorrows? Help get us to the finish line. Next slide, Neil. And now I am going to turn this over to someone you've met before. Allow me to introduce Alyssa Tompkins. And Alyssa is a partner and our litigator at Casa Sakely LLP. We have had nothing but encouraging comments in all quarters about the performance of our legal team year after year. Alyssa is with us tonight, and Charles Dove, now with David Sauvé, LLP, has the evening off. I have to say why. Charles lives and works in Centertown. Enough said. He deserves a night away. So, Alyssa, it's all yours. Thank you.
Thank you so much, Barbara. And thank you, as always, to everyone here, to the KGPC, for continuing to allow me to represent you. This is such a great cause, and it's a privilege to be able to make these arguments on your behalf and to be part of your fight. So I'm going to provide an overview of the court proceedings. The OLT hearing was handled by another lawyer, Sylvain Rouleau of Rear Folds of Toronto. So my knowledge of the OLT proceedings has been somewhat limited. So just for the purpose of the questions, I'm afraid I won't be able to answer much in that regard. But turning now to what we've been doing. So the Supreme Court, the City of Ottawa, did indeed seek leave to appeal to the Supreme Court of Canada. Now, as some of you know, that is a difficult process. So on average, the Supreme Court grants leave in about 8% of civil cases. So while it's great news that the city sought leave, we do have to manage our expectations in that regard. That said, seeking leave to the Supreme Court of Canada requires parties to establish an issue of the test as public importance. And we thought there was such an issue, and counsel for the city agreed. And again, I'll also give a shout out to Councillor Curry, who I believe was very important in ensuring that our contributions were facilitated to the city. So we definitely noticed an improvement in the level of collaboration and cooperation at the city. So just so everyone knows, we were given a full opportunity to review the city's draft factum. Charles and I made extensive comments, and our comments were incorporated and addressed in the final draft. That is different than what happened at the Ontario Court of Appeal. So what are we trying to overturn? So I'm sure anybody who cares enough about this issue to be here tonight knows about the decision. So yes, the Ontario Court of Appeal struck clauses 5, sub 4, and 9 as being void against the rule against perpetuities, which is a very ancient property law rule that provides that an interest in land can't vest or transfer in remote times or after 21 years. Put rather simply, there's a lot more complexity behind that. So in the event, that the city is able to get leave, then they would only have permission to bring an actual appeal before the Supreme Court of Canada. So the leave process is just to get permission to actually bring an appeal before the Supreme Court. But like I said, it's a significant barrier. So it's a very important one. So in terms of the timeline, the city filed its response its application in late January. We anticipate Clublink's response. I didn't calculate the date, but it's 30 days from whenever the city's application was filed. And then there's an opportunity for the city to reply. It's a very limited right of reply, only I think 5 pages max. And I believe they'll have 10 days to do that. After that point in time, it goes into the hopper at the court and things get a little bit opaque, though we know that generally speaking, there's about a 4 to 6 month wait period. I actually just did one for the City of Ottawa in another case where we actually won at the Ontario Court of Appeal. The developer, Charles Ford, in that case sought leave, and that was dismissed last Thursday. And I believe their application went in September. So We are looking there at about 6 months, 5, I think. I know that because my baby was born in August and he's 6 months. So if their application went in September, it's 5 months, but that's about the order of time that we're talking about. So that's happening. In the interim, some of you may remember that because the Ontario Court of Appeal only struck clauses 5, sub 4, and 9, the question remained before the Court of Appeal, well, what do we do about the rest of the agreement? And the Court of Clublink had tried, as some of you may recall, to get the Court of Appeal to strike it. And we were in quite a panic about that because they had not actually asked for that in their notice of appeal. So that was not something they actually had a right to ask the court for. We had asked the city to advise the court of that, and for reasons I have no idea, they declined to do so. We were initially, when we decided not to intervene, it was on the basis that we didn't think the court would ever do that. So I'm very pleased that they didn't, thank goodness. But Clublink nevertheless tried to make an end run. So that's really the type of, when Barbara talks about unforeseen things coming up in this litigation, pretty much anything that Clublink can do, they have done, so as to make things more difficult for us. So that's just a reality of dealing with a deep-pocketed opponent, but it's something that we have to respond to. They sought costs from us. We had to respond to that. They did not get costs, but again, it's an unnecessary and an unanticipated step that we were forced to undertake. So because only the remainder of the agreement was remitted to Justice Labras, the question remains, when will that application be heard? The city has taken the position that it should wait until their leave application is determined. We have agreed with that and have advised Clublink of that. Clublink, of course, disagrees and wants to forge ahead with the application before the remainder of the application for Justice Labras. And consistent with what I just said about them, they have already signaled that they are going to contest the coalition's standing to even make submissions on the enforceability of the remainder of the agreement. And some of you may recall that at the initial application hearing way back in July 2020, we're the ones that actually made that argument, not the city. So we were the ones that originally argued that those provisions could be severed. That was the argument that we called severance. Clublink responded and we replied. The city did not take a position on severance. Finally, on reply at the very end, the city advised the court that they supported our position on severance. But that was our horse in the battle. And the reason is we said we don't care about clauses 5, sub 4, and 9, because we say the rest of the agreement creates a restrictive covenant for the benefit of the community. And the court said, I can't deal with this right now. You're going to have to start your own application. So we're going to come to that. But coming back to this issue of the enforceability, the first step, I believe, will be our submissions on why we should be allowed to make submissions on this point. And I will, of course, point out that, well, we've already made submissions on this point. So there'll be other points made as well, but I'm not going to disclose them at this time for reasons of solicitor-client privilege. But the next step is March 1st. There's a case conference. Clublink demanded it, and Justice Labras has vacation that week, but has agreed to hear us at 5 p.m. And Clublink will undoubtedly insist that this must proceed urgently, and the city is going to say it needs to wait until our leave application is determined. We'll support the city, but again, our ability to really influence the process is a bit limited when we're the intervener. So we're lucky here that we're supporting the city as opposed to trying to drive the process itself, particularly when we're going to have to make submissions to be included. The last thing I would want to do is suggest that, it's inconvenient to us. But obviously it's wasteful to proceed with this while the city's leave application is pending. And that's the submission that we'll make, that we're a community funded organization and we don't want to waste legal fees on an issue that may become moot in the event that the Supreme Court grants leave. So given that, the leave is the initial hurdle, we'll definitely pitch it as we should wait for leave. If the city actually gets leave, then I suspect everything grounds to a halt. Next slide, please. So Barbara and I have both alluded to this. So indeed, yesterday, the coalition filed and a notice of application was issued. This is the coalition against Clublink. So the city is no longer involved. This is us directly against Clublink. And that, of course, brings cost concerns as well, because not only is the coalition responsible for its own cost, but in the event we're unsuccessful, and we believe we're going to be successful, that's why we're doing it, but the coalition is now more exposed to a cost award. So again, this is really taking the bull by the horns. And as Barbara said, we're driving the bus now. And we've done this because, so these two restrictive covenants we originally raised in our application, in the city's application. There's one arising from the 40% agreement. And those are the arguments that I made at the July 2020 application hearing that Justice Labrosse eventually said, I don't think I have enough evidence. The city won anyway, but coalition, you should bring your own application. So at the time we said, the city won. So, there's no point in us wasting our resources on that. And we wanted to spend our money best supporting the city at the Court of Appeal and now in their leave application. The second restrictive covenant, we initially raised it in our factum. For any of you who read really closely, we filed a factum, I believe, in February 2020 before the proceeding was adjourned. And we did make that argument at the time. We ultimately decided that it made the most sense to wait, because at that point we were just seeking a declaration that that restrictive covenant was valid. So the first restrictive covenant, as some of you may recall, was one that it doesn't look like what we would expect a restrictive covenant to look like. So a restrictive covenant is a document that's generally registered on title, and it limits what a property can be used for. It's generally it is restrictive. There's something called a positive covenant, and the positive covenant is saying somebody has to do something. Those ones are much trickier to enforce, whereas a restrictive covenant more says what you cannot do. So we're saying that you cannot build on the 40% of the land, or it needs to be kept as open space, green space. And that's a type of restrictive covenant that has been enforced. But as you'll recall from the hearing, it wasn't clearly, it's not registered on title like a normal restrictive covenant. So we had to cobble it together from the 1988 agreement, from the documents incorporated by reference in there, the plan of subdivision and the infamous concept plan that you all heard a lot about at the hearing. And that will undoubtedly come up again this time around. So that's sort of a conceptual, I would say an implied restrictive covenant. So that argument, it's an argument we already made, but we're going to refine a little bit. The second one, it looks more like a traditional restrictive covenant. It's actually registered on title on the golf course lands as such. It's if you pull the pin, the parcel register, it'll be there. And what it deals with is stormwater management and grading. So that's a restrictive covenant that Clublink registered in 1996 in favor of, it was Imasco at the time, I believe, that owned the lands, and they were eventually sold off to, well, all of you, or those who are within the immediate vicinity of the golf course. So that one deals with stormwater management and grading. So this is where there's an overlap between what we're doing, and what Sylvain and our expert Doug Nuttall were doing before the OLT. So we're hopeful that a lot of that work will be relevant, but it's a different question in the sense that what the restrictive covenant provides is that Clublink cannot alter the grading or the stormwater management in a way that materially adversely affects, and that's going to require some legal argument as to what that means, but materially adversely affects the City of Canada or Imasco's stormwater management plans as they existed in 1996. So of course, there's no document that's called stormwater management plan. That would be too easy. So we also have to reconstruct what constitutes that stormwater management plan. And our expert has already had to spend some time thinking about that. So that's the second restrictive covenant. So we're seeking declarations that those are enforceable. With respect to number one, the 40% one, there's going to be a big fight there. The second one, I'm unaware of what arguments Clublink might raise that it's unenforceable. What they could do is argue that it should be expunged or something to that effect. I'm not sure, but enforceability doesn't appear to be an issue. The question with respect to the second one is the further declaration we're seeking, which is that Clublink's proposed development breaches the restrictive covenant. And that's going to require expert evidence from Doug Nuttall, possibly someone else, but I think just Doug will cover it. But the process for an application, it's what happened with the city. So an application is you proceed on a written record. So unlike an action where you would have a trial, an application proceeds on the basis of a written record. So you have affidavits, then you have out of court cross-examination. So usually before a court reporter, we get transcripts. Then we do written argument. You've seen reference previously to what we call a factum, which is just a written legal argument. Then we have the oral argument, which is the hearing. So it'll proceed in a similar manner as the city's application. The exception is that I think there'll be more work to be done at the cross-examination stage because both parties will be leading expert evidence, and cross-examining experts is considerably more involved than the very narrow cross-examinations that Clublink did of a couple of the city's witnesses. When you have expert evidence, a lot turns on the cross. So in that part of it will be more work. The written argument, we've done a draft basically, and we're just going to refine it. So we're trying to be as efficient as possible. But as I've said, there's constantly curveballs from Clublink and steps that, we wouldn't necessarily anticipate a reasonable, cost-effective litigant to be taking, but perhaps a, unlimited pocket litigant that wants to do everything possible to make things difficult for a community organization litigant. That's frankly what we're dealing with. So that's the reality of the situation, and we're doing our absolute best to keep legal costs down. But when Clublink, seeks costs against us of a massive amount, when they say that we don't have a right to make arguments we've already made, we are forced to respond, and that does take time and effort. So that's where we're at. This is a big step, the notice of application, because we're driving the process now. Again, there is a responding party, which is Clublink. There's the court, but we're no longer just an intervener, and we're no longer, trying to appease the city. The city is not a respondent or not a party to our application. So at this point, we've taken control, and we had hoped that the city's argument would succeed and that this wouldn't be necessary. But since the Ontario Court of Appeal decision, and there was arguably a limitation period coming up in this matter, we thought it was an opportune time for us to get this in the system, get it scheduled, and hey, if the city gets leave to the Supreme Court of Canada, maybe both sides will agree to adjourn this until that date. But it's important. This is an argument that Justice Labrosse said we would need to bring our own application for, and we are now doing so in light of the Ontario Court of Appeals decision. So that's where things are at on the court front. And I think I'm right on time, 7:45. So I will pass the speaking to our next speaker, and of course, stand by to receive questions about this, about my presentation and the legal front anyway.
Thanks so much, Alyssa. The trek is a long and expensive one. We value your expertise and your guidance. I don't know where we'd be without you. And I will say to our supporters, while she cannot predict everything, her worst case scenarios have been spot on. And we've lived every one of them. The unpredictability of it all is what we must try and plan for. It is difficult to do. Today, I again ask you to think about how can you help us save our green space? What are your memories and what are your tomorrows worth? Thanks, Neil. Next slide, please. The next person up is a fixture in our community for a long, long time. Jeff McGowan and his partner, Bobby, ran a pretty prestigious Remax operation, which surely has given him and her both an incredible level of awareness on the residential market and what we're living and what we're facing here. He has an update for you on some of the possible impacts if Clublink is successful, pushing for profit and destroying the very essence of our community. Over to you, Jeff.
Thank you very much, Barbara. And thank you, Alyssa, for your excellent presentations. I think that, well, I'd also like to thank all of the people who are watching this for not only your interest, but dare I say, your commitment to preserving our community. And I think you can all agree that based on what you've heard so far, we've been busy defending the community. My task this evening is to talk about the potential impacts, and I would even take it a step further to say the more than probable and definite impacts that will occur should Clublink be successful in being allowed to proceed with their development proposal. And I'd like to lead off by talking about lifestyle and enjoyment of the green space. This is going to be a daily thing that everyone's experienced in the community. Early morning walks, evening walks with the dog in the summertime, wintertime when the golf course lands become a playground for the community with cross-country skiing, snowshoeing, sledding, skating on the ponds, pickup hockey games. There was even a snowboard park built on the #1 hole last year. It's an important habitat for wildlife. It contributes to cleaner air in the community, and it is visually pleasing and good for mental health because the reduced density provides a great quality of life. Dare I say that the soul of our community is good for our soul. Next slide, please, Neil. So lifestyle, I think, is a given. I think we all know that already. I'd like to move on to the macroeconomics and business development aspects of what the green space brings. Next slide, please, Neil. The Canada North Technology Park is a world-class institution. It's known worldwide. It's a major contributor to the attraction of world-class talent in our city. It's a significant player, and the economic benefits that it brings to the community don't stop with just the employment of the people working in the technology sector. They spill off in many ways in service sectors, retail, and supporting all of the people in the community as an affluent and well-trained, professional, white-collar workforce. People are attracted to Canada, and we are well known as a great opportunity in the tech sector because of the lifestyle that we offer. And our green space is a major, major contributor to that. So that definitely needs to be considered in any discussion about impact. If we lose the green space, we lose a competitive edge. And I think that's very important. If I could go to the next slide, please, Neil. Real estate is, for those of you who know Bobby and I, been our living for the last 38 years. We've done a lot of business in the area, and I think we're pretty well qualified to speak to what the impact is likely to be on real estate. On principle, I believe that it's wrong that buyers were assured that the golf course green space was protected by contract, and now we're faced with the current challenge. Homeowners invested in this community in good faith, and that good faith must be defended. In a hot market like we have right now, buyers may look the other way with regards to potential negative issues around a real estate transaction just to secure a home in a tight supply market. This is evidenced by the acute run-up in home values over the last while. The waiver of inspections, the waiver of financing conditions, and the acceptance, in many cases, of known defects in a home just to secure a home. This is not a normal condition, and it reflects one end of the market scale. Next slide, please, Neil. The other end of the market, there are more homes for sale than there are buyers, and only the most aggressively priced, unique, or impeccable homes will sell. Prices often decline in these markets. Next slide, please, Neil. The more common market is the balanced market. Supply and demand are in balance, and prices usually rise roughly at the rate of inflation. This is the most common type of market in the Ottawa area. We are a stable city. We are usually not subject to the wild swings that you might see in other markets. So that's real estate 101. How does this impact the development proposal and the effect that it will have on real estate values? Next slide, please, Neil. Quite simply, it will have a serious and permanent negative effect on the value of all of the homes in Canada Lakes if approved, and a somewhat lesser but still significant effect on the surrounding areas. Let me explain. When the last golf course view lots were sold in Canada Lakes some 15 years ago, they commanded a $130,000 premium over the value of non-golf view lots. So to be clear, a home or a lot on one side of the street was fetching $130,000 in land value more than the identical size lot across the street. The neighborhoods of Bridlewood and Canada Lakes were developed in the same time frame beginning in the 1980s, with several builders offering the same floor plans and finishes in both neighborhoods. Identical homes were priced higher in Canada Lakes on comparable non-golf course lots. If we move forward to today, golf view lots in the Equinel development in Kemptville currently command a $100,000 or higher premium over non-golf course lots. Now, it's a fact that property values are greater in Canada than they are in Kemptville. Value is partially determined by convenience, access to amenities such as recreation, shopping, our downtown core, the airport, train stations, etc., etc. And that's why you've often heard that the three most important features in a home are location, location, location. The conclusion to be drawn here is clear, and it's based on the well-defined principles of property appraisal. If this development is approved, golf course homes will lose a minimum of $100,000 in value in a balanced market, and possibly more. Non-golf course homes will lose somewhat less. We would estimate in the order of $25,000 to $50,000 due to reduced desirability of the neighborhood. If we lose features, it's not as desirable to a buyer. Property in the surrounding areas of Beaverbrook, Village Green, Canada Estates, and Heritage Hills, to name a few, will feel a lesser financial impact, but they will still be affected. We at the Canada GreenSpace Protection Coalition have been working diligently to protect the community's interests legally, morally, and financially. We've invested thousands of hours of time and hundreds of thousands of dollars to work towards those ends. And now we seriously need your significant financial support to continue the opposition, as Barbara has said several times. Now is the time to step up and defend your important investment. I believe that it is reasonable to ask for every homeowner backing on the golf course to contribute $1,000 to protect their investment, and for every homeowner in the area to consider a minimum $500 contribution. We all pay far more than that to protect our vehicles, to buy extended warranties on appliances, etc. It just makes sense to protect your home value. For those of you who have said to us, when you need the money, just ask, I will write you a check. Well, my friends, now is that time. I would urge you to talk to your neighbors who may not be attending the town hall tonight. Tell them it's time to support the GreenSpace Coalition. It's important. Your community needs your support. It won't be easy, but together we can save our neighborhood. And I'll pass it back to Barbara at this point. Thank you.
Thank you so much for that, Jeff. And if I can make you feel better, we've had, while you did that presentation, $3,000 come in, Jeff. So I know that we have also had a very strong week financially with the announcement. So folks, you too can make a difference. We realize what we're asking because we're asking ourselves to make those donations too. And we recognize that the time to make the donation, the time to invest in the work that the coalition is doing is now. Tomorrow may not come. We have taken the fight to Clublink, and we believe there's an argument here to be won. And we believe there's a community to be defended. And we know there's an economic future in Canada North that is worth protecting as well. So please, if you have any more questions, the email address for tonight is townhall@ourcanadagreenspace.ca. We're a few minutes ahead of time. We are certainly here till 8:30, and we're happy to stay a little longer. Neil, do we have another slide? Could you remind me, or are we just at questions and answers now, I think? And I should turn it over to Sue Dodge, who is going to handle that. Our panel's all going to light back up, I believe. And we're going to try and field some of the questions that have come in over the past week and some of the questions that have come in tonight. So Sue, thanks so very much for doing this.
Okay, great. So I'm not sure who's going to answer some of these questions, but let's start with this. Let's start with this one.
I think Alyssa should do the legal ones.
Okay, well, we'll do that. All right, Alicia, in plain language, what is a restrictive covenant?
Plain language, that's a very difficult challenge for a lawyer. It's a property law, I was about to say instrument. It's something that's registered on title that restricts the manner in which land can be used. So it has the force of property law, and it's recognized under the Land Titles Act.
Okay, thank you. Here's another one. I'm not saying who these are from. I hope those people don't mind. I'm not sure who should answer this question. So the question is, the Court of Appeal of Ontario stated that Clublink started exploring the development of the golf course lands for residential and open space purposes. This raises two questions. What open space development has Clublink put forward? And is Clublink interested in increasing the membership? I presume this is the golf membership, given they earn more money with development. Has Clublink done anything in recent years to increase the club membership?
First part of the question, maybe I could take a crack at, because I spent every day for several weeks monitoring the OLT. I'm going to try and be unbiased in my answer, but it is a little bit difficult. What we have now is 70, almost 71 hectares of open green space. Clublink and its designers were happy to tell the OLT Tribunal that 30% of their proposed development is still green space. Even though they've been instructed not to, in that calculation, they've included stormwater management ponds, which the city will fence and are not available for public use. They will not be swimming pools or ponds or a place to go float your boat. They are a functional stormwater part of the stormwater management system. So if you extricate their stormwater management ponds, I cannot tell you how much of their site is green space, but they do have small protected woodlots. And I say small because they're all being pared down from what exists currently, and 2 or perhaps 3 parkettes, which have children's play structures in them, etc. So that is what is being called green space. And if in your mind you're scratching your head and say, well, how does that get anywhere close to 30%? They do include curbs and front yard setbacks and everything else inside that 30% as well. So I think that gives you some good sense of how little green space and open space there'll be. I can't think of anybody better than my husband, than Jeff McGowan, to talk about the Clublink and Clublink membership and the golf. Maybe Jeff has a word or two on that part of the question.
Just to clarify, Barbara and I are not married. She's referring to Michael.
Yeah.
Just as an addendum to your answer, Barbara, in terms of the percentage of green space, I can tell you that I believe the Ontario Municipal Act requires 5% green space in a new development. Mm-hmm. And I would suggest that the proposal would be somewhat less than that if you take the stormwater management ponds out, from what I've seen in the concept plan. To address the golf course question, I can tell you that I'm pretty well informed on that, as I am a member of the Canada Golf Club and have been for nigh on to 30-some years now. Clublink has not been actively pursuing new memberships. They have been selling some new memberships because one of the interesting byproducts of COVID is that golf has boomed. Not only in Canada, but right across North America. And golf tee times and golf memberships are difficult to come by now. So Canada is designed to have roughly 425 full-time members. We currently have about 320 because they've capped sales. We had sales guy pretty well. He's been told don't sell any more memberships. So I think that's about as direct an answer as I can give there.
We're not selling memberships, but we're taking donations. And Jeff, we just got 2 more $1,000 donations. Just saying, guys.
Nice.
Come on, Canada North. You can do this. You can do this. Bring on the question, Sue. You're doing a.
Oh, I was just going to interject too that from a legal perspective, what the status of the membership is not relevant. Clublink led evidence on this point at the application, but we never cross-examined it because it's not relevant. The agreement allows them, they can desire to discontinue the operation of the golf course. They don't need to like it doesn't speak to what the reason is, or it doesn't say that, you know, if the golf course is unprofitable or anything like that. So that from a legal perspective has never actually been relevant.
Good to know.
Okay.
Good to know. And here comes another $1,000 coming in. Thank you so much, Alyssa. Sue, bring on the questions.
Okay, this is a question for Alyssa. Why are the chances of getting to the Supreme Court so slim?
It's just because of the number of cases that the court can hear in a year versus the number of applications. So I'll note that the number of cases they hear in a year has been going down. So I was a law clerk at the Supreme Court of Canada way back in 2007, 2008, and the court regularly heard at least 90, sometimes over 100 cases a year. They're now down to 50 or 60 cases a year, but they get hundreds of applications. So they only hear the ones that are truly issues. The test used to be national importance. They've actually broadened it to be public importance. So if you had a really important issue in one province, it could still get leave. But basically, you're looking to show the court that there's something that requires its urgent attention. So usually things like conflicting Court of Appeal decisions. What you don't want is to just say the Ontario Court of Appeal was wrong. We need to say not only they were wrong, but it creates a whole level of uncertainty in the law. And look, BC says something different, and now people aren't going to know what to do. So the court is very selective just because there's so many cases. Plus, criminal cases have a different test. If there's a dissent there, they have an as of right appeal. So the court's docket is very full with criminal law cases as well. So that's why we end up with, like I said, on average, 8% a year of civil cases.
Alyssa, that was an excellent answer. It earned $1,000 donation. Harley, my 12-week-old Newfoundlander, that's him barking in the background. He probably sent $1,000 if he had it too. Sue, away you go.
Okay,
Great
so
job.
I don't know who wants to answer this question, but it's been a question that I've had. So the city planner stated that there was no need to amend the city master plan in order to proceed with this development. However, apparently our experts believe that this can't proceed without a change.
I can probably speak to that, and then maybe Alyssa can follow up on it. It's my understanding that, and I think you're talking about the official plan, not the master
I
plan.
think it's the official plan, yes.
So it's my understanding that the official plan references the 40% agreement, but that it is not formally ensconced within the official plan. And I think that the city continues to believe that the 40% agreement and the unsuitability of the site for development should preclude any development in the area. And they're not relying on the official plan as a firm stop on it.
We had taken the position that the 40% agreement was in the official plan as a matter of policy. We said, in fact, the city couldn't tie its hands contractually, which is one of Clublink's arguments. We said, no, they did nothing of the sort. It was there as a matter of policy on its own. And that to develop it, they would need to change that. That's certain. We made that argument in passing in court, and I believe it was consistent with Dennis's report.
Dennis Jacobs tied it as well to the entire situation with the GREENSPACE master plan and a reference within that as well. So there are interpretations, and it is interesting. I wish we had Dennis. We'll do another town hall, and we'll bring our other experts in as well, because these town halls are valuable to people. We had just crossed with that little dialogue another $3,000. So I think it is important for people to hear that there is confusion about this issue, but our expert, Dennis Jacobs, was actually the person in the position of directional policy through that official plan development. So it is hopeful, and I would suggest that the city's view has softened from the beginning of the process to the end of the process as to how opposed they are to the official plan amendment. So I think there is still some discussion to be had there. I get a little bit of credit for some of the money that came in on that one. Sue, next question.
Okay, so if there's a question here, I think this has been answered, which is what's the deadline for the city to appeal to the Supreme Court after the Ontario Court of Appeal decision? I think we answered that. Like
The deadline was the end of January. I can't recall the exact date, and they met it. It was the 25th or the 26th. They met it. We had the draft, I think, the Thursday prior. So they had the whole weekend to incorporate our comments. So it was very well organized. And they had Guy Pratt come in, who's a very well-known litigator out of BLG. So they brought in some Supreme Court experts, shall we say. But yes, it went in on time. We don't have Clublink's response yet, but it's imminent, I'm sure. And then, as I said, there will be a brief reply from the city. I expect we'll be asked our thoughts, but it's 5 pages max. Usually when I do it, we actually do a letter in a way to give it the back of the hand a little bit.
So Alicia, I have another little question here related to this. So with this application underway to the Supreme Court, how can Justice LaBrosse rule on anything?
Well, it's funny, Barbara and I had that discussion yesterday, and certainly that's the city's position, is that while this application is before the Supreme Court, that the remainder of the application dealing with the enforceability of the remainder of the agreement should wait. We support the city on that point for the exact reasons that you're stating. It would seem obvious. Clublink's position, and they sent us a letter to that effect, is that basically now that the OLT is winding up, that they want to, basically they're assuming they're going to be successful and they want to have everything tied up. So they want this dealt with as soon as possible so that they can proceed with their development. Everybody knows that leave applications have a low chance of getting accepted, even though I believe the city's application is strong. The final product was very good. I think they successfully did raise an issue of public importance, but then it just becomes, does the court want to hear that particular case? But they definitely met the test. They had a very strong final product. So even with that, though, there's a whole black box in the leave process that we don't really understand. So we're stuck with the numbers, which are 8%, and they're undoubtedly going to say to Justice LaBrosse, we can't wait on this remote chance that the city gets leave to the Supreme Court. The city, though, is going to say, and I'm going to say, let's wait at least till the leave applications determine what's the rush. The leave application should be done summer, September, that we could do it then. That's what we'll push for. But Clublink has already signaled their intention to proceed full steam ahead.
Susan, do you have another question?
I do. I have a couple
Before
more.
you ask it, can I thank the very generous donor that just sent us $2,000? Thank you.
Awesome.
And can I thank the other 5 donors who sent us $1,000 each? Thank you, thank you, thank you. This volunteer is very grateful. Susan, fire away.
Okay, so I have some other legal questions, but I'm just going to throw this one out. So someone has asked, why can't we just get our money together and buy the golf course?
Some bright person said to me the other day, you can't buy what's not for sale. And there is an argument, regrettably, that Clublink feels it has a way to manipulate the situation and create value in this golf course land that doesn't exist as a golf course. And it would appear that pleas from the community to redirect itself do not matter. It's going to pursue this. So the reality of it is, if they are of the belief that they can get a gazillion times the value for the land as a construction site, and two great Ottawa businesses are prepared to pay to be a piece of that, I should mention them by name: Minto Communities and Richcraft Homes, because I have spoken to other developers who say, I won't let my community be a part of that. That is why we can't buy a golf course. Now, is it, can you turn your head to it? Should we turn our head to it? There's no indication that Clublink is interested in that. They know in their industry who's prepared to buy that golf course. And I'm not a golf course expert or in that fashion. I'm only an expert in paying Clublink's golf dues for my husband every year. And everyone here should understand how painful that is to contribute that. I love my husband dearly. And that's a statement on how much I love my husband, that despite what has happened to my life over 3 years, I still pay his golf dues every year. Having said that, it doesn't make sense, does it? But the reality of it is, Sue, I think a wise man named Jeff McGowan once said that to me, that you can't buy what's not for sale. And I think that is where we find ourselves. And I would say it goes to the logic in my own mind. It goes without saying that when they find out they can't develop their land, we'll find out, do they still want to be in the golf business, and how dedicated they are to their golf members here in Canada and as part of their Clublink family. And maybe the situation will be different at that time. If I could just add on, the corollary question is the city, the two clauses that the Court of Appeal overturned were directly related to the city, the land turning back to the city at some point in time. And the city has already kind of gone on record that it doesn't really want to be in the golf course business anymore. But for those people who worry about that, you should not, because there are a lot of other avenues which the city has tried to get its head around as to how it would reassume those lands under that condition and keep a golf course, and or at minimum keep the green space and the open space. But that's where we are from now. And I don't want to say that we've won a prize, but I believe we've just had a $5,000 donation. And so thank you to those kind donors. So another question.
Okay, so I'm just going to ask Alyssa this question. So why can't the community take a class action against Clublink?
Well, it's still on the radar, but we would need a cause of action. And a cause of action is kind of the legal hook to commence a claim. We can't just commence a claim and say, Clublink, we don't like what you did. We have to base it in a legal cause of action, whether it be negligence, we're not privy to the contract, unjust enrichment, nuisance. We'd have to figure that out. But all of those causes of action require actual damage. So we can't just commence it in a speculative way. We've also been trying really hard to do this in as efficient a manner as possible. So as I said, that's why we delayed commencing the application, even though Justice Labrosse's decision said, you should start your own application on the restrictive covenant. We said, well, we don't need to if the city wins. So we waited until the city did not win, at which point we started moving in that direction. So again, that's still possible, but to complete any of the causes of action, there would need to be actual damage. and I'm not sure exactly how we would define damage yet. It would depend on the cause of action, well, whether it's a shovel in the ground, whether it's a loss of land value. But at this point, I don't believe there's damages. So no limitation period has started ticking. And I'm sure when it does, if and when, like, that's when we'll turn our minds in more detail, because it's going to have to be creative. There's no cause of action that immediately springs to mind, but you know, I was creative, and I read enough that I believed there was a restrictive covenant, and I believe that it does exist, but I had to sort of piece it together from different things. And once I did that, I believe the elements of the test are all satisfied, but it's the same kind of analysis would need to go into the cause of action for a potential class action. But yeah, basically most civil causes of action require damages. So, and surely a class action would not be seeking a declaration either. You would want and sadly the damages would be compensatory. So that would mean that, you know, we were unsuccessful in the other veins, and we're at that point seeking compensation for the loss of your green space.
Speaking of that, Sue, if I could jump in again, we've got a note here that just came in. I've lived in Katimavik for 27 years. Losing the Beaver Pond Forest to the same cause was painful enough. How do I donate? And I have a slide about how to donate, but the simple way to do it, folks, and we'll get to it in a minute, but if you're trying to donate now, it's our website, ourcanadagreenspace.ca, and on the home page, there's a green donate now here button. Thanks, Neil. We take e-transfers. We like e-transfers because there are no service fees, and all of your donation fights Clublink. Automatic deposit, no codes. The information is right there on our webpage. We also take checks. The address is on the website, and we'll collect your check if you would prefer it. And credit cards as well through our GoFundMe site, but your donation is reduced by the service fees. So once again, ourcanadagreenspace.ca, and thank you again for the $5,000 donation. Sue, any more questions?
I have some more questions. So here's one that I actually think is a pretty good one. I'm not sure who's going to answer it. So someone writes, I read recently something about the Ford government blocking a development in Willowdale because it was unsuitable. Did Janice Jacobs not say that this planning application was not infill and was not suitable design, given the nature of the homes which surround it and are Canada in nature? Would this be a possible attack strategy or defense strategy?
I can answer half of that, because the proposed development in Willowdale was actually a modular development designed to house 76 homeless people, to be built on some surplus land in an existing subsidized housing development. So I don't think the parallels are there between us and that, but I'd be interested to hear Alyssa's comments on what she feels in terms of the strategy might be along that line.
I just don't know enough about the situation. Suitability speaks of planning language. So it's probably a better question directed to Sylvain, but there's a lot of residual approvals in the Planning Act. So it doesn't surprise me that the minister could technically overturn a planning decision, but suitability, again, I think Dennis or Sylvain would be better to address that. Presumably those, I can come. Sorry, I'm reading Neil's comment. I'll try not to pay attention. But yeah, effectively, I assume the language I've always heard used in planning spaces is compatibility, not suitability. But I know that the issue of compatibility would have been live before the board or the tribunal. So again, it would surprise me that that argument hadn't been raised already, and maybe you just I'm more familiar with the agricultural scheme, but there's a sort of a rubber stamp appeal to the minister, but we never actually think we're going to succeed on that. Like you go to the local marketing board, the tribunal, then there's like this potential appeal to the minister, but we never think we're going to succeed. Maybe this one did. But yeah, I don't know enough about it. But we can definitely, whoever asked the question, we could direct it to Sylvain and Dennis, and they could decide who is best positioned to answer it.
We could definitely get that answer, although Neil, Neil spends a lot of time on this for the KBCA. If you maybe has a short comment he wants to make on it. Thanks, Neil.
Yeah, I mean, I've worked at, I know everything I know from working with Dennis on this topic. And his comments with regards to this is, number one, the fact that the 40% agreement is in the official plan says, even if it's defeated, it's still a plan of record for the area. Second question is on, he's made the comment, this is not infill. And that goes to do with what the city's definition in the official plan of what infill is. It's the removal of a single family home or something of that size and replaced with a multi-unit. It's not 1,500 homes as infill within an established community. So the city actually doesn't have the ability in the official plan to say yes to this. And that's why his comment is, your official plan doesn't allow you to agree with this because you have no provision for this kind of development.
Neil, someone out there liked your answer and sent $1,000. Thank you for that answer, and thank you for the contribution. Next question, Sue.
Okay, so these are slightly different questions. So if we already have overcrowding in the schools in Canada, and why doesn't the city establish some kind of ratio as to how many schools can be serviced by so many homes? And, you know, is this part of the issue?
I think again, that would be, Neil's saying up to the school boards, but I think Dennis would be in the best position to answer this because all of that is dealt with in the planning process. I'm quite sure it would be in the plan of subdivision, like all the, they do studies involving schools, existing servicing, all of that.
Okay.
But we can still take note and ask Dennis and he can respond.
Okay. So is the city, this is a question, I'm just going to paraphrase this. Is the city after the tax base that it's going to get from these 1,500 homes? Is that why they're not being, there's another question related to this. Let me read it. There's a lot of questions here. Hang on. Okay, so this question is, what is with the city? They seem to be very weakly represented at the OLT and the appeal. I almost feel embarrassed for them, but more importantly, they don't seem to be really helping in our fight.
I'd like to take the first part of that as it relates to the city's desire for revenues, and then pass it over to Barbara for the second half. So the reality of it is of course the city needs revenue. That's how the city runs. And the city particularly needs revenue now because we're faced with an OLT that is in dire need of repair. We've had COVID, we've had a convoy occupying our city for the last 3.5 weeks, and attendant costs there. But to say that the city needs development on the Canada Golf Course lands or any of the green space protected by the 40% agreement, because it is more than just the golf course lands. There are other parcels of land that are involved with that, primarily around Kaizel Pond. I think it's a spurious argument at best, and just a false argument. And the simple reason is they don't get any more development fees or taxes out of homes built on those lands than they would out of homes built on the over 8,000 approved lots in the Canada area right now. There are 8,000 homes that can be built in Canada that are already approved. And there are land banks surrounding Canada that are in the process of being approved. And there's probably 40 to 50 years supply at minimum that is slated for development. So they don't need this land, and they're not going to get any more money or any less money, whether it's developed or not. So that question is always, or that argument is always puzzled.
Well, I think it speaks to the awkwardness of the situation at times. And I tried to comment on that when in the opening. I mean, I think the reality of it is we focus on Canada North issues because that's where our home is, but we're part of a larger pie. And I do understand that there's a constant rationalization, and I think most people do, of services. How do you create a city? How do you manage a city? And how do you drive it forward in an equitable fashion? And that is something we're constantly faced with. And lately we've been faced with it a lot more. I can be honest with you, as I work as an advocate for Canada North across Ottawa and with our elected representatives, I've had them say to me, you folks, you're a bunch of rich white people that live on a golf course. People actually say that to me, and I'm quite offended by it, to be honest with you. Not because I don't understand the color of my skin, I do, but I am a 1/8 Aboriginal Canadian. I may not look it, but that's who I am. And I think we have to get beyond these kind of name calling, my backyard, your backyard. What I do understand is that in Canada North, we are in the wonderful and fortunate situation that the Bill Tarrans and the Compos and the Marianne Wilkinsons before us had the good sense to craft this document. Why? Because urban centers should have accessible green space. And we are lucky enough to have 175 acres of it that we have a right to use. Do I think there should be an equal amount of green space in Overbrook or Vanier or in City View? Personally, I do, because my background is healthcare and I understand the importance of the environment and of accessible green space to recreation, to physical fitness, to mental health, some of the things Jeff alluded to earlier. I get it. I get it. But none of us win if we let organizations like Clublink and their current partners, Minto and Richcraft, operate in this kind of way in our city. Our city doesn't win. We certainly don't win. But more important, the residents in the rest of Ottawa don't win. And the representatives that are fighting for fairness and equality in the rest of Ottawa, they don't win either. So that's my long-winded spiel on, yeah, it's about tax dollars. It is about tax dollars. I agree. But we also have to recognize there has to be a fairness and there has to be a recognition to what communities want. And you don't have to think hard. Communities and residents and taxpayers now see the value in environmentally appropriate policy to protect our climate and protect our ability to live in these urban settings.
And Barbara, if I could just speak on the equities, I think the distinction, and I live in Westboro, I'm an Orleans girl, but I live in Westboro now, where there's a great deal of intensification. Our ward councillor is saying, I have intensification, why shouldn't you? Well, to me, the equities are that you thought that you were protected by the 40% agreement that Clublink assumed. It assumed those obligations when it bought the contract and when it bought the golf course. And that was provided for in the original contract, that it could only be sold if the next purchaser agreed to respect the agreement. So when I moved to Westboro, I knew full well there could be intensification. There is constantly. I live in an infill property, a semi-detached home. But none of you bought your property or chose to live in that community with that understanding. So to me, that's the part that some of them are missing. That
it is what makes our case singular, Alyssa, and I do point that out to them. But that doesn't mean we're not open to understanding what it looks like to other people.
Oh, agreed.
But the reality of it is, you're quite right to remind us all, at the center of our particular argument is not just the value of green space, it's deeds to land that lists and shares that entitlement of access. And Clublink acknowledged it and undertook that, and they're trying to walk away from it. Thank you, Alyssa.
So I really only have one other question, which is about,
See, it's 8:35. Maybe we can squeeze it in.
well, so it's about whether maybe we should find people to run in various capacities with the city and the province that support our cause, to make sure that we, like, is that necessary, or are our liaisons strong?
Maybe we could all take a crack at the question, but I'll gladly give you my thought, because I say, hell yes, this is a democracy. And I think that the best communities are the communities that have quality representation. And that goes to my former argument about fairness. Some communities, it's hard for them to get fair because it's hard for them to get good quality representation. And I think that what we do need to do here in Canada North is reaffirm with our representatives that we have quality representatives. And I suggest in some cases we certainly do, but we also need to reaffirm to them how important environment is to us. And I know that several of them tell me that they get it, they understand it. Kathy Curry certainly does. She tells me she gets this issue. And this is her a key issue for her. Doesn't mean she doesn't struggle with others. But yes, I think it is important. And I will tell the table that and our supporters that I have reached out to the Liberal candidate, given that there's an election coming up in June. I have not heard back from Shanaz. So I'm trusting that in some good course, I will hear from them and we can have that discussion, because my answer to that question is hell yes. If this is a central issue, if this is so big an issue that homeowners in this area are going to pay upwards of $10,000 and more a year in property taxes. I don't know all the numbers, but these are the numbers that are put to me. And then yet again, we have to go and fund these kinds of legal actions to protect ourselves. Then I say we have to keep double checking with who is representing us. I agree.
I think
Yeah.
Barbara said it well for all of us. I have nothing to add to that.
Thanks, Jeff.
Yeah, my observation is that since we've had Councillor Curry on board, I have sensed an increase in cooperation from the legal team at the city. That's my observation. I read into that what you will, but that's something I've observed, and it's been helpful.
It is helpful. It's really helpful as a community advocate to be able to talk with someone and get their support and get their commitment, and then see it followed through. And I think every taxpayer and every resident in every community deserves that at all levels of government. Is that it?
Well, there's one that just came in. I'm just going to ask the first part of it, which is, what is the relationship between our action against Clublink over the restrictive covenants and whatever Justice LaBrosse will eventually be asked to consider?
Oh, I am afraid I didn't make that clear. That's an excellent question. So yes, the hearing before Justice LaBrosse is essential because there's two restrictive covenants. One, the stormwater one, we'll park that one. That's going ahead no matter what. That's the one that deals with materially adversely affecting this 1996 stormwater management plan. Park that. The other one we say arises from the 40% agreement, and we say it arises from the other clauses. So section 3 that sets out the 40% principle, the section 7 of the 1988 agreement that provides that it runs with the land for the benefit of the community. So if Justice Labrosse strikes down the remainder of that agreement, we have nothing left on that front. There's no more clauses. Certainly of the 1981 agreement, I'd have to consider whether there was an argument in relation to 1988, but our argument gets considerably more difficult if he strikes the entirety of the 1981 agreement. So we definitely don't want that to happen. And it's one of the reasons our submissions that we should have standing to make submissions on that point are so important as well, because the community's voice absolutely needs to be heard, given that we say it creates this restrictive covenant for our benefit. The restrictive covenant has nothing to do with the city. It's Campo basically tied his hands or his company's hands for the benefit of the community, which is the landowners that are now all of you. So that's a great question, actually, and I had meant to highlight that in my presentation. So thank you, whoever asked that. But yes, that's why the logic of it makes sense that the Labrosse hearing on the remainder, I think it should proceed after the city's leave application, then our applications, which has the 2 restrictive covenants, but that's a separate court proceeding. And I'm not sure if Barbara has circulated it yet, but we did get the stamped version from the court that has so it'll have a new court file number than the city's application.
No, we haven't circulated because it came in late yesterday, but I will be putting out an e-news this week, and we will put a link up on the website to the actual document so everyone can read it for certain.
It is just a notice, though, it's a notice of application, so it's not our legal argument, which will come later in the factum. Just in case everybody finds it's quite high level, that's appropriate for a notice.
Wonderful. Okay.
So Barbara, I think that's kind of it for the key questions.
Thank you, Sue. Thank you for doing this. I think and we're at a good point where I think we can look to wrap this up. Neil, if you could take us back to our slideshow. I thank Alyssa and Jeff for sharing that with me. Thank you so much to our generous donors. This has been particularly special and particularly overwhelming in some ways tonight. So I am going to let Neil just take us back to where we should be. I'm not sure, is this, I think we're back a slide, Neil, no? No, another. I think one more slide. We lost our order. I'll go from where we are now. So in wrapping up this evening, I think it is important, and I hope we've convinced you that this is not a KGPC fight. We alone cannot defeat Clublink, but our community will. And we need your help to do it. We're approaching the end of this long trek. And yes, it's been long, but we have been narrowing that focus, the planning focus, the legal focus. And together we're starting to hone in on what will be the end. Next slide, Neil. I do want to remind everyone that Neil, thanks, Neil, that there is an opportunity for you to do something today and help save our green space. And if not today, I would ask you to reflect on this. If you've got a question or a concern, I would be happy to spend time with you. Please call, please email. You do anyway. Please stop me at Loblaws. It doesn't matter. Harley and I will be soon out on the golf course. and for our walks. And I'm happy to talk about it with you. Honor your memories, honor your tomorrows and the tomorrows of your grandchildren and your family. Help us get to the finish line. $1,000 may not be something you can afford tonight, but $500 matters. $100 a month matters. And in fact, we're going to get back to you about a program that'll let you do that too, because we'll still be at this for a while, and we realize that. Thank you very, very much for your support. Neil, I think our next slide reminds everyone of our website addresses again, if I'm not mistaken, or yes. So just a reminder, our website, you can donate 24/7 at arcan@greenspace.ca. The homepage, there's a green donate now button. It lets you sign up for our e-news. If you're not signed up for our e-news, please do. It's our best way to communicate with you, and also sign up for our social media, our Facebook pages, because sometimes when things are happening in a hurry, we spit information out there. So e-transfer checks, we'll gladly pick them up, and credit cards as well. Thank you so very much. I think there's one more slide, Neil. And again, to Alyssa, Jeff, thank you very much for helping with this tonight. Karen and Neil behind the scenes, and Sue for a great job on questions and answers and parsing them on the fly. We really appreciated that. Folks, help us finish this. This is something you deserve and our community deserves. Please stay with us. We need your support. In the meantime, always take good care. Stay safe. Good night, Canada.